Participants. How many participants do we have, Anjali? More than 40, I believe, right? More than 40. And is this an independent session or is this happening since morning?
It's an independent session.
Independent. All right. All right. Thanks.
Sir,
So
it's just starting now.
just starting now. So all right. So very warm welcome. In fact, very cold welcome from Delhi. So I don't know from where you all are coming, logging in, but
Mostly
uh,
we are from Delhi only.
from Delhi only. Okay.
Yeah.
Cold and polluted welcome then.
Yes.
Okay.
Yes.
So
Yes,
then,
yes. Most of us are from Delhi. Correct.
all right. So then, uh, but anyways, so our subject here is on anatomy of IBC law, case laws. So recent case laws is what we are going to discuss in this 3 hour session that we are going to have. And I hope everyone here is an IP, or are there people coming from other professional backgrounds also? I
IP
mean,
is a
it's
Yes, yes.
only
I am
IPs,
cost
only
accountant.
IPs, no? All the IPA members, which means, right? ICSI IPA members. So, uh, well, we are going to discuss around 8 case laws, all of the Supreme Court, mostly passed after June 2025, in this year itself. And quite interesting developments have happened. If you see the case laws, they are also giving, raising certain issues, very different, varied issues. For instance, whatever we're going to discuss, we'll see. So
Sir,
what I'll endeavor to do is
ठीक है सर देख लेंगे कोई दिक्कत नहीं
just kindly unmute mute your mic, sir, Rakesh Mishra ji. So uh, Rakesh Mishra ji, kindly mute, sir. Yeah, thanks. So we are going to discuss 8 case laws. After first 4 case laws, perhaps we'll try to take a break around 10-15 minutes, and then we'll again continue with the session. So I'll share the slides with you. I'll share the PPT.
Apoorv ji, you are on mute.
Yeah, can you hear me now?
Yes, yes, yes.
Right. So just, I hope everyone can see the screen.
Yes.
Yes, yes. Sure.
So as we discussed, so we are going to discuss about some case laws, relevant case laws, recent case laws of the delivered by the Supreme Court of India. The very first case is what we are going to start is EPC Constructions India Limited versus Matix Fertilizers and Chemicals Limited. The neutral citation is 2025 INSC 1259. The judgment is passed in October 28, 2025. So a very recent judgment. And so what facts of the case, just to discuss the background, that EPCC had entered into an engineering and construction contract with Matix for a fertilizer complex at Panagarh Industrial Park, West Bengal, with outstanding dues of around 572.72 crores. Matix proposed converting 400 crores of dues into preference shares. So EPC's board approved conversion into 8% cumulative redeemable preference shares, which Matix allotted 25 crore CRPS of rupees 10 each, totaling to 250 crores with 3-year redemption period. So when CRP was initiated against EPCC and Matix failed to redeem the CRPS after the 3-year period expired, EPCC filed a Section 7 petition claiming 310 CRPS redemption amount as financial debt. Now, the NCLT and NCLAT dismissed the petition, holding that CRPS constitutes an investment forming part of the share capital, not a debt, and preference shareholders cannot be financial creditors under the IBC. So that was what the NCLT and NCLAT had held, that Section 7 petition was liable to.
वो जो आप कर रहे थे ना अमाउंट के लिए, तो एक बार जो है आप मेरा चेक
Yeah,
करो
just
कितना आ सकता है, तो फिर मैं
kindly
आपको
unmute,
डॉक्यूमेंट्स
kindly
जो
mute,
चाहिए वो
sir.
दे दूँ, प्रोसेस आप कर सकते हैं।
So, the issue before the Supreme Court
बेसिकली
was that the question.
प्रॉपर्टी तो ले रहा हूँ, प्रॉपर्टी में प्रॉब्लम ये है कि
Sir, kindly mute yourself. Yes. So, in this factual background, the question that arises for consideration is whether the NCLT and NCLAT were justified in dismissing the application of the appellant under Section 7 of the Code after holding that the appellant was not a financial creditor. And so, the relevant legal provisions relating to the cases are Section 7, we all know, Section 5(7), which is financial debt, subsection 8 of Section 5, which is defining financial debt. Then 5(8)(f) about the provision relating to commercial effect of borrowing, which constitutes a financial debt. Section 3(11), which is about debt, definition of a debt. 3(12), which is about definition of a default. And subsection 37 of IBC, which mandates that terms undefined in IBC but defined in the Companies Act shall carry the same statutory meaning. Then relevant provisions of Companies Act. First is 284, which defines share capital, defines the share as a unit of share capital, confirming its character as equity rather than debt. Then Section 43, it classifies preference shares as a form of share capital carrying preferential rights to dividend and capital repayment, but not creditor status. So, which is important. Then Section 55(1) and 2 of Companies Act, they permit issuance only of redeemable preference shares and subjects redemption to strict statutory conditions. 55(2)(a) of Companies Act, it restricts redemption of preference shares exclusively to distributable profits or proceeds of a fresh issue of shares. So the definition itself, redemption is exclusively for distributable profits, or it is for proceeds of a fresh issue of shares. Then Section 123 of Companies Act, it prohibits payment of dividends where the company has incurred losses or lacks distributable profits. Now, the relevant observations of Supreme Court in the backdrop that what it holds is that it is well settled in company law that preference shares are part of the company's share capital and the amounts paid up on them are not loans. Dividends are paid on the preference shares when company earns a profit. This is for the reason that if dividends were paid without profits or in excess of profits made, it would amount to an illegal return of the capital. Amount paid up on preference shares not being loans, they do not qualify as a debt. So their observation is made, preference shares, they are not treated as loans, they are not treated as loans, and they will not be qualifying as a debt. It will be clear from para 34, it will be clear from a plain reading that to maintain a proceeding under Section 7, an application has to be filed by a financial creditor, and the application has to be filed when a default has occurred. It will be noticed from the above that for a default to kick in, there should be a non-payment of debt when whole or any part of the debt has become due and payable and is not paid. Admittedly, the CRPS had not become CRPS is cumulative cumulative redeemable preference shares. They had not become due and payable since the respondent had not made profits and did not have any reserve out of the profits made in the past, nor did it possess any proceeds from a fresh issue of shares made for the purpose of redemption. In this admitted scenario, the question of there being any default under Section 312 of IBC does not arise. Hence, the argument that the 3 years period mentioned in the CRPS for redemption having expired, the shares were due for redemption, does not carry the case of the appellant any further. So, even when the period for redemption had expired, the Supreme Court has held that that will not be treated as a default of a debt, since that the right to redeem preference shares is also not a debt in itself. Further observations were there that the CRPS were at a stage when the redemption period had expired would not lend greater weight to the case of the appellant. They continue to be preference shareholders, and by being preference shareholders, they do not enjoy the status of creditors of the company. Hence, they do not fulfill the definition of a financial creditor for the purpose of Section 7 of the Code. Then, para 46, another important section in the IBC to be noticed is Section 5, subsection 8, which prescribes that to be a financial debt, there needs to be disbursal against consideration for the time value of money. And 5.8c does not talk of preference shares, while it talks of note purchase facility, bonds, notes, debentures, loan stock, or any other similar instrument to the categories mentioned thereunder. The omission is significant as demonstrated above. The paid up money on shares being share capital, they do not constitute debt. As far as Section 58F is concerned, before we deal with the term commercial effect of borrowing, the opening clause of 5.8 cannot be lost sight of. It has to be first a debt, and such debt would be a financial debt if it is raised under any other transaction, including a forward sale or purchase agreement having the commercial effect of borrowing. As already explained, the paid up amounts towards shares do not have the character of debt. The further argument that redemption was due is also not meritorious. As required under Section 55 of Companies Act, the shares could be redeemed only out of the profits or with any amount kept apart for dividends, which is not the situation in the present case. So since the company does not earn profits, so that is why the preferential share allottees would also not get anything in return. That does not mean that there is a default committed by a company, because first of all, there has to be a debt. So holding of preference shares, as we've already seen, observations of Supreme Court in these 5 paragraphs, holding of preference shares by itself does not constitute holding a debt by a company. If that happens, then there's no point of having a preference shareholder. Ultimately, is a shareholder. He is not a financial creditor. He is not a creditor.
In other words, can we say that preference share will always remain a shareholder? It cannot be at no point of time under any circumstances preference shares can be treated as a debt. Can we say this?
It can't be treated as a debt. That's what the Supreme Court
Yes.
holds. So,
And
yes,
Supreme Court has basically upheld what NCLT and NCLAT held.
NCLAT has held. So
Yes.
they have dismissed the Section 7 application. And in fact, Companies Act itself, if you see Section 123, just below, prohibits payment of dividends where the company has incurred losses or lacks distributable profits. And so there has to be, if there is a distributable profit, only then preferential shareholders are paid by the company.
Yes.
So in case a company does not earn profits, that does not mean that there is a commission of default. There is no debt, so there can't be a default. Because these are all dividends which are being paid on a preference share.
Yes.
Any doubts in this? We have done with the first case.
Yeah, this is absolutely right.
Quite
Absolutely
straightforward
clear.
also, but a
Clear.
very different issue. Perhaps I think Supreme Court has not dealt with this issue before. So this went up till Supreme Court because such kind of matters also don't go till Supreme Court. This went up till Supreme Court that where this itself, this whole uh, redemption under a cumulative preferential share, which is under that scheme itself was taken in question whether it will be constituting as a debt or not. This itself, so even if there is a liability to pay, liability of a company to pay the preference shareholder, that liability will not constitute
Debt.
as a payment of a debt.
Hmm.
That liability is for payment of a dividend on a preference share transaction. So that is what has been clarified. And uh, There is
And
another significant observation because challenges to this ruling of NCLT and NCLAT were made in two, three manners. First, the appellants had tried to also say that it's a default. Then they say that I am a financial creditor. How? Because it is also having a commercial effect of borrowing. So that argument was also rejected by the Supreme Court. And then they also took shelter of Section 5(8), which prescribes that financial debt need that Section 5(8), which provides for which does not provide, it specifically excludes preference shares. It talks about purchase facility, bonds, notes, debentures, loan stocks, but it does not talk about preference shares. So, in a way, in para 46, if you see, Supreme Court makes it clear that legislative intention was also very clear that while defining financial debt, they kept preferential shareholding transactions out of the definition of financial debt. Similarly, in the 5(8)(f) also, in para 47, Supreme Court clarifies that commercial effect of borrowing will be only of a transaction where there is a debt. First, there has to be a debt, and those such kind of transactions should be a forward sale or purchase agreements. So, preference shareholders are not qualified in any of the definitions of financial debt.
And even in Section 53, the distribution, the waterfall mechanism, you will find that the preference shareholders are held before equity shareholders. The equity shareholders are there
Yes,
at the end, and preference
yes,
shareholders are before them. So that means there
yes.
also law has very categorically said that they are shareholders.
They are shareholders, so they are
They are
not
getting it last
part of
but one.
financial
Last but
creditors.
one.
Correct.
They
So they are not part of financial creditors. They are
yes,
not falling.
sure.
They are not uh, given same preference as financial creditors also in the waterfall mechanism. That is also a correct observation.
Yes.
Right. All right. So second case, is there any other question, doubt, or any other observation by any of the participants except for this one? So shall we move to the second case then? Right.
Yes, please.
So second case is just a second. Yeah, so the second case relates to is namely AA Estates Private Limited versus Khair Nagar Sukh Sadhan Cooperative Housing Society Limited. Also a recent judgment passed in November 2025. Neutral citation 2025 INSC 1366. Facts, we'll deal with that. Respondent, which is Housing Society, it had entered into a development agreement with AA Estates Private Limited for redevelopment of its for redevelopment of its property, under which the developer was required to obtain statutory approvals, arrange finance, and commence redevelopment within stipulated timelines. However, the developer repeatedly failed to perform its contractual obligations, did not achieve financial closure, and caused prolonged delay. So the developer here was making defaults. He was not performing its contractual obligations on time and was delaying the development of the project. So that led the society to issue notices and ultimately terminate the development agreement and supplementary arrangements well before the initiation of a second CRP against the developer. Subsequent to such termination, the society appointed a new developer and approached statutory authorities for redevelopment permissions. So the society, after terminating the development agreements, approached the statutory authorities for again redevelopment permissions, which actions were challenged by the erstwhile developer on the ground that the initiation of CRP and the moratorium under the IBC barred termination, redevelopment, and grant of permissions. So many issues were involved here. First was that whether the termination of the development agreement and supplementary agreements also by the society prior to the initiation of second CRP of the developer was valid and effective in law. Then whether the development agreement and the supplementary agreements constitute assets or property of the corporate debtor so as to attract the protection of moratorium under Section 14 of the Code. So this is also an important issue, whether such agreement by itself would constitute an asset of a of a corporate debtor. Then whether the High Court was justified in allowing the writ petition, because the writ was filed by society, directing the statutory authorities to process and grant approvals in favor of the next developer, who was the respond number 8 for redevelopment of the subject project, and whether the proceedings before the High Court stood vitiated by breach of the principles of natural justice as alleged by the appellants. Relevant legal provisions for this case, Section 14 IBC, we all know, moratorium, which prohibits the institution or continuation of proceedings in respect of assets and enforceable rights of corporate debtor as on the insolvency commencement date. Then Section 65, which confers residual jurisdiction on the NCLT to adjudicate question of law and facts in relation to CIRP. Section 238 IBC, having the overriding effect over other laws. Then Contract Act, it recognizes the right of termination of a contract to the party to a contract. And Article 226 of Constitution in India, which is regarding the writ jurisdiction to a High Court. So the judgment of Supreme Court, the relevant observations that we have copied here. First was that the termination of the development agreement dated 16th October 2005 and supplementary agreements by the society was valid, lawful, and effective in law. So first they upheld the termination, having been carried out after due notice and in consequence of prolonged and inexcusable default by the developer. The society, as the owner of the land, was entitled to revoke the contract and appoint a new developer to protect the interest of its members. So here, the Supreme Court has clarified the owner of the land was the society and not the developer. So it was entitled to revoke the contract and appoint a new developer also to protect the interest of its members. Second observation, the aforesaid development agreement and supplementary agreements do not constitute assets or property of the corporate debtor within the meaning of Section 14 of the Code. So, rights and obligations under agreements will not constitute assets or liabilities in that sense. Rights under an agreement to develop a project will not be constituting as an asset, which will fall under the moratorium provisions. The said agreement stood validly terminated prior to the initiation of second CIRP, and hence no subsisting or enforceable rights survived in favor of the corporate debtor. The third observation was then the High Court, it was justified in entertaining the writ petition filed by the society and directing the statutory authorities to process and grant approvals in favor of the next developer, who is respond number 8, subject to compliance with law. Such directions are procedural in nature, did not encroach upon the jurisdiction of NCLT, and did not contravene the moratorium under Section 14 of the Code. So, which means the appellant had also stated that by invoking Article 226, High Court had intervened in the jurisdiction of NCLT. So that argument was also rejected by the Supreme Court. Then, last observation, the proceedings before the High Court were conducted in substantial compliance with the principles of natural justice. The appellants were afforded a fair opportunity of hearing, and no real prejudice or failure of justice has been demonstrated due to the proceedings of the High Court, concerned High Court. So in a way, Supreme Court in this case has upheld the rights of a society who is the owner of the concerned land, and even if the developer it goes into insolvency, and here the relevant part is also that even the agreements were terminated prior to commencement of CRP of the developer. So prior to commencement of CRP of the developer, if any agreement is terminated, then naturally in any which case moratorium would not have been effective at that time. Second, if this argument is taken that any developer goes into insolvency, then can that developer be allowed to hold development of a project whose property that the landowner is actually not the developer itself? So that would really amount to injustice to the real owners of the land also. So that's why society went into writ, because perhaps license was not issued by the concerned statutory authorities. So that's why the society filed a writ petition under 226 of the Constitution. And this project relates to just a second. So the society went and filed a writ. So High Court had entertained the writ, also recognizing the right of the society, being the owner of the land, that it can do anything if somebody is not abiding by its promise to complete a project in time, then it can very well terminate the agreement, and post termination can also appoint another developer can enter into contract with another developer and can obtain further licenses from the statutory authorities. So quite straightforward. So going into insolvency by the previous developer would not stall the project, cannot stall the project. That was the clear message by the Supreme Court. So what it is. Any observations, any questions relating to this particular case? So
Basically, these society owners would be home buyers only, most of them, I'm sure. So,
should be, because it's a society. So
yes,
society definitely have many members who might be the allottees, who
yes,
will be future allottees also. So that
yes,
society. This is a because this is you see, this is Kher Nagar Sukh Sadhan Cooperative Housing Society. So it's a cooperative housing society.
yes, yes, yes. So basically, it is in favor of the society. The
Yes.
judgment is in
So
favor of
A Estates Private Limited was the developer. Now,
yes,
there was delays on behalf of the developer, there was a termination. So I believe a good judgment from the society's point of view, and
yes,
especially at establishing that the owner cannot play in the hands of a developer
yeah,
who is not even the owner of the assets, who is not the owner of the moved properties. So just because he goes into insolvency, then the project cannot be stalled.
yes,
So in that way, a good judgment.
yeah, absolutely.
However, I've seen in many such builder disputes, wherever these infrastructure projects, when they go into CIRP, sometimes the promoters also make, though this is a cooperative house society, it's a very different matter. But sometimes amongst builders only, the promoters only, they make different companies. The land is owned by one company, the developer is the other company, and if the developer goes into CIRP, ultimately the developer enters into agreement with all the home buyers. So in such cases, perhaps it will be a different scenario. It can be a
Mhm.
different scenario.
True, true,
But
true.
here it's very different. Since it's a cooperative housing society, so which has itself having a different statutory recognition. So we have to distinguish such kinds of cases with those cases where the promoter itself is floating a developer,
Yes,
and then the developer enters into exclusive agreement with home buyers. So that is different from this one. Any doubts or questions? So interesting.
Sir, may I please?
Anil ji.
Sir, in a case where like it's a private landowner having a joint venture contract with this real estate developer, and the
Mhm.
company has the same in the similar situation that has also come into CIRP second time, and
Hmm.
the period of the joint venture agreement between the landowner and the company is expired long back, and now
Just a second. Joint venture is between the landowners and
and the company that CD,
developer.
yeah.
Right.
Now, the company is in CIRP right now.
Hmm.
Whether the landowner can come out of this agreement and say, the land belongs to me and the CIRP cannot progress.
See, interesting question. That's why we have to see assets, who own the assets. Second,
Assets is owned by landlord and he has not given even for the bankers. There is
yes,
no authority given to the CD to even hypothecate or create an encumbrance on the property for any borrowings, and that is not been done. And the
no, but
period, yeah,
then why is it called a joint venture agreement?
joint venture is because they have see this. There he has invested his land, and the developer is taking all the financials and all the approvals and the processes what he is doing for the development, and that is why it is a joint venture.
No, sir, in fact, see, I tell you, joint venture, since we have to see joint venture agreement, which means do they create a separate entity?
No, no, no. It,
Do a
it
joint
is
venture?
not. It is not joint venture in that. It is a joint development where landowner has given the land, and that's all. And that is also given that he will not, create any encumbrances till the means the whatever funding is to be raised, he has to raise, without the lands being given as a security.
So the developer goes and enters into agreement with all the home buyers or the land here
Landowner.
in
This is the developer only enters into the agreement based on this
with the home
agreement.
buyers,
Yes.
right? So that's
Yeah.
a different case scenario. That's what I've said.
Okay. Okay.
Because in such cases, home buyers' rights are involved, and see, in this particular case, society's members are the landowner, are the ultimate allottees of the project.
No,
Housing societies.
do you mean to say that this there is a distinction or a distinguishing that because these society members are house owner, that is home buyers, that
Yeah.
is why they are given this treatment, but it is not a joint development per se, where a landowner has given only the land and the promoter has failed in fulfilling his obligation as per the joint development.
Yeah, so that's the difference because see, cooperative housing society, we all know, it is formed by for the members only. Members of the society will be the allottees. They themselves undertake to develop a project. The society itself undertakes to develop a project, maybe through a developer, third person, but it is meant for the society itself. Now, the circumstance you are talking about is one landowner enters into an agreement that yes, I will give you the land,
Yes, sir.
enters into agreement with the developer,
Yes, sir.
and then the developer will do everything. He will make everything.
Yes, sir.
He will make all the towers and etc. Whatever
Yes,
he
sir.
will take
Yes, sir.
all the
Yes, sir.
he will take RERA compliances and everything,
He will
and
do everything. He will give me
he will
40% of the built up area. He will
yes,
keep 60%
and
of
then
me.
he will also collect money from all the home buyers. That money
Absolutely.
doesn't
Absolutely.
go. That money does not go to the landowner, right?
Absolutely.
And
Landowner gets 40% of the built up area.
40% of built up area or profits.
No, 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 no. Built up area. Like with 1 lakh
40%.
square feet, the 40,000 square feet will be given to the landowner. 60,000 will be
Okay.
sold by the CD. That is the
Okay.
build.
Okay.
That
Okay.
was the agreement in my case.
So which means 40%. So 60% is what the developer
Sell
can
it.
sell.
Yes, absolutely.
60% is what the developer can sell, and
Absolutely.
40% the landowner can retain by for himself or will sell through his own. I mean, the
Absolutely.
developer will have no rights. Yeah.
Absolutely.
So so that's why this case is quite distinguishable from the AA estates case that we are discussing.
Okay. Okay, sir. Okay, sir. Thank you.
So we can't say specifically that landowner, by taking shelter
This
of this
case.
judgment, can say that I can terminate the contract with the developer. And who goes
Okay.
into insolvency in your case? Developer only?
Yeah.
Landowner is a private individual.
Landowner is two individuals.
Two individuals. Right. Yeah. So we can distinguish it. We can
Okay, sir.
definitely distinguish it because this is related to
Apoorv,
cooperative housing.
Apoorv, this JDA, this Joint Development Agreement, is a
Ji.
very common thing,
Common
particularly
thing,
in South,
correct.
very common thing. So this is
Correct,
there
correct.
in vogue, and what Mr. Anilji is saying, is absolutely right, because
Right.
there's some agreement at the very beginning when they execute this Joint Development Agreement, whether
Correct,
it is
correct.
with 30/70, 40/60, whatever it is, the ratio is
Yes,
already
yes.
decided, and
Correct.
the landowner gets the flats, okay, or the built-up area in lieu of this, and it is his
Correct.
prerogative whom he wants to sell. The builder The developer, he sells it to the individual home buyers. That is the thing. And then the home buyers come into picture. So you are absolutely right,
Correct.
Apoorv, that this is AS Estates Limited and what Anilji is saying are two different,
Two different scenarios. Two
two
different
different
scenarios.
scenarios. Totally two different
Different
scenarios.
scenarios. Though the concept they are explaining here, you can match it. Somebody from the landowner side can actually argue based on this case, but I think it can easily be distinguished by a good professional.
Yes.
I get you completely.
Right.
Thank you so much.
Right. Any other doubts or questions related to the case number two? Okay, so the third case now that we will discuss is Amit Nehra versus Pawan Kumar Garg. Judgment rendered on 9 September 2025. It's neutral citation 2025 INSC 1086. Now, this is also related to real estate project. Here, the appellants were home buyers. They were the allottees of a real estate project of the corporate debtor and had submitted their claims during the CIRP. So they had submitted their claims during CIRP, that is important to note. Although their claims were initially filed with defects, they were subsequently resubmitted, duly verified, and admitted by the RP, and included in the final list of financial creditors published prior to the approval of the resolution plan. However, under the approved resolution plan, the appellants were treated as belated or defaulting allottees and were denied possession of their allotted apartments, leading them to challenge the orders of the NCLT and NCLAT, which upheld such treatment. So the resolution plan itself kind of discriminated against these allottees by holding them to be belated or defaulting allottees. And that also when the RP had verified and admitted their claims before the approval of the resolution plan. So though the claims were initially filed with defects. So this is what we have to note. Now the issue here is, which falls for the determination of the Supreme Court, is whether the appellants, being allottees of an apartment in the project Aereo Rise Gardenia Mohali, developed by the erstwhile corporate debtor Puma Realtors Private Limited, and having admittedly paid a sum of rupees 57 lakhs odd out of total consideration of around 60 lakhs, are to be treated as belated claimants entitled only to refund of 50% of their principal deposit under clause 18.411 of the resolution plan, or whether they claim, having been duly verified and incorporated in the list of creditors, they are entitled to possession in terms of clause 18.46A of the resolution plan. So this is the moot question. So whether they can be treated as defaulting and they will be entitled to only a refund of 50%, or whether they will be entitled to possession. Relevant legal provisions, 58F, it treats amounts raised from lotteries in real estate projects as having a commercial effect of borrowing. They are FCs. Section 18(1)(b) and 25(2)(e), they cast a statutory duty on RP to receive, collate, verify, maintain claims of all creditors in accordance with the CIRP regulations. We all know all these provisions. Just a revision, short one. Regulation 13 CIRP regulations, we know RP has to verify, claim, maintain list of creditors. And then Section 31 provides for approval of resolution plan, which is binding on all stakeholders, but only in respect of claims that are lawfully classified and dealt with under the plan. 65 empowers NCLT to adjudicate questions of law and facts. Now, relevant observations of the Supreme Court. Para 33, we are unable to countenance the approach of the NCLT in brushing aside this admitted position, which is that in treating the applicants as if they had not filed any claim at all. The publication of the list of financial creditors is an act in discharge of a statutory duty by the RP. It cannot be reduced to a meaningless formality. Learned counsel for the appellants has rightly placed reliance on Puneet Kaur, which is a NCLAT judgment of 2022, wherein it was observed as follows. So these are observations of the NCLAT in Puneet Kaur. However, we are of the view that the claim of those home buyers who could not file their claims, but whose claims were reflected in the record of CD, ought to have been included in the IM, and resolution applicant ought to have taken note of the said liabilities and should have appropriately dealt with them in the resolution plan. Non-consideration of such claims which are reflected from the record leads to inequitable and unfair resolution, as is seen in the present case. To mitigate the hardship of the appellant, we thus are of the view that ends of justice would be met if direction is issued to the RP to submit the details of home buyers whose details are reflected in the records of the corporate debtor, including their claims to the resolution applicant, on the basis of which the RA shall prepare an addendum to the resolution plan, which may be placed before the Committee of Raters for consideration. So these were the observations of the NCLAT in Puneet Kaur, which the Supreme Court relies upon to state that since and I believe in this case before the NCLAT, the claims were also not filed by the home buyers. In fact, they were there, they were reflected in the record of the corporate debtor. They were not filed. So even in such cases, it was held that such claims should be included in the IM, and resolution applicant should prepare an addendum to the resolution plan and place it before the COC for consideration. So in this background, in this backdrop, the RP rightly admitted the claim. This is what the Supreme Court holds ultimately. In this background, the RP rightly admitted the claim of the appellants to the extent of rupees 57 lakhs odd and reflected it at serial number 636 in the list of financial creditors. Further observations then, what is critical to note, para 37, what is critical to note is that this is not a case of entertaining a fresh claim beyond the resolution plan. It concerns an allottee whose claim was verified and admitted by the RP and reflected in the list of financial creditors well before the approval of plan by the NCLT. So here the claim was filed, though there was some defect, but also verified, collated, and admitted by the RP much prior to the approval of the resolution plan. To disregard such an admitted claim and confine the appellants to the limited benefit under clause 18(4)(11), which is about 50% refund, it is not to preserve the binding effect of the plan, but to misapply it. So they have made a distinction here. They have made a distinction that the question before them is not whether there is a binding effect of resolution plan, but first we have to see that whether the plan has been misapplied or not. Clause 18.4 itself draws a clear distinction between verified claims and belated or unverified claims. To obliterate that distinction would render the scheme odious. So distinction between verified claims, belated or unverified claims, that is already there. And then delegating bona fide allottees who have paid substantial consideration years in advance to the status of mere refund claimants runs contrary to the very objective of the legislative framework. The facts of the present case highlight the plight of individual home buyers who invest their life savings in the hope of securing a roof over their heads. The appellants had paid nearly the entire sale consideration as far back as 2011. To deny them possession today, despite their claim having been duly verified and admitted, would inflict unfair and unwarranted prejudice. In light of the foregoing analysis and reasoning, the appeal merits acceptance, judgment of entlat set aside. And then respondents were directed to execute conveyance deed and hand over possession of apartment in Mohali to the appellants within a period of 2 months. So, of course, being home buyers, they gain natural sympathy from the courts. And this is what happened in this case also. But legally, or for us to understand or to deliberate upon, is about the application of resolution plan. So if the resolution plan creates a distinction, but if that distinction itself is kind of discriminatory, it does not a resolution plan cannot discriminate between verified claims, is what the Supreme Court is trying to say. So something which is a belated or unverified claims, but where the RP has verified a claim, also included it in the list of creditors, and that is also before the approval of the resolution plan. So then such claim cannot be held to be belated claim or unverified claim, because the appellants who were there before the Supreme Court, whether they will fall in the category of the verified claims or unverified claims, that was the moot question then. If they were verified, which is on record that the RP had published the final list of financial creditors prior to the approval of the resolution plan. So in such cases, the resolution applicant cannot discriminate against such a financial creditor in class and say that they will be entitled to refund because their claims were not verified. So that is what the Supreme Court has tried to hold. And in fact, in Puneet Kaur NCLAT, even in cases where the claims were not filed, even in such cases, the RA was directed uh, to prepare an addendum to the resolution plan so that their interest is also taken care of, even of such financial creditors in class who had not filed their claims, but whose claims were reflected in the record of the corporate debtor. So in this case, they had in this particular case before Supreme Court, the appellants had a much better case because first they had already filed their claims, though they were defective. Then they were verified, collated, admitted by the RP also prior to the approval of the resolution plan. So they were on a much stronger footing. And of course, being home buyers, I've already said, they always gain sympathy from the courts. So a very interesting case also, because even if someone is not able to pay the entire amount, because 60 lakhs was the entire consideration and they had paid only 57 lakhs. So maybe under the resolution plan, there might be an opportunity to such persons to pay a bit more and then get the allotted unit to the under the resolution. So they ultimately got the benefit through the order of the Supreme Court. Any point of discussion?
Sir, may I?
Ji, Anu ji.
Sir, in a case where no, there are in such situation where home buyers are there, there's a case where half of the home buyers, approximately half of the home buyers, have cancelled their booking, and
Have cancelled their bookings.
yes,
Okay.
and
Prior to
claimed,
CR.
prior to GRP, and they also claimed refund, and some of them were. The CD himself has informed them that their bookings are cancelled because they could not make the payments in time. So both the situations are so. There are three types of home buyers now. One is the surviving home buyers who have been paying their installment in time and to whatever extent till the CIRP comments, they have made the payment. Second one is those who for any reason ask the refunds and ask the cancellation. And third is those who could not pay the installments in time.
Cancelled allotments.
Are the
Cancelled
cancelled.
allotments. Right.
Now, whether these three types of home buyers, whether the resolution applicant can make a distinction in this particular case, not to take it longer, there are home buyers who are live home buyers. They say other home buyers should not be given the homes. They should be only made the payment because they were only the investor. They were not a genuine home buyers. So I just thought to bring it to your notice, whether it is relevant to discuss it here or not, you can take a call.
No, correct. Why not? Why not? We should share our different experiences on a particular issue.
Yeah, that's the
Maybe not
purpose. That's the purpose.
Plus, we are dealing with home buyers here. This is the second case relating to the real estate project. So, of course, the purpose of having this webinar is perhaps to discuss all kinds of issues that we are confronted with. And otherwise I can share this PPT with you and everyone can read what is there in the judgment. While dealing with this, we are discussing a particular topic, and in relation to that, all doubts that come in our mind, we can deliberately learn from each other so that so what you're saying, sir, is that whether the RA can make a distinction amongst those three categories,
Yeah.
right? First is about the cancelled allotments, where the builder has where the CD itself has cancelled the allotments because of failure of the home
Install.
buyers to pay on time, right?
Yeah.
Pay on time. So they have, so which means cancellation of allotment, which also means termination of agreement. But we have also
Absolutely.
asked whether in such cases the CD had already refunded the amount after
No,
cancelling,
no,
or he had
no,
forfeited the amount.
no, no, not forfeited, not refunded. In fact, the CIRP started and they are all the claimants now. And the IRP has, RP
Admitted the
IRP has
claims.
admitted all the claims.
Admitted the claims even after cancellation, right? Which means,
Yeah,
right.
yeah, because
And
everywhere there was in the books, there were all liabilities were there.
yeah, entries were there. So, correct. Second is the those home buyers who have not done anything, they are just happily paying the installments but did not get the possession, right?
Yeah,
And the third ones are, which you are saying, the ones who have already claimed refund. Yeah,
absolutely.
you're muted, sir.
Yeah, absolutely.
Yeah,
These
so
are
they
three
have already,
categories.
no, the ones who have already claimed refund, they were also given the refund by the CD prior to
No,
CIRP.
no, 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 no. They are all now the claimants. There are three categories of claimant: the home buyers. The second is who demanded cancellation, and third, the CD cancelled them. So all the three are the claimants, and all claims are being accepted by the RP.
Yeah, so see, so then I believe as far as the first two are concerned, since the claims are admitted, but in the claim for, we also have to see, I mean, just a technicality here, but since we are discussing it without verifying each and every fact. So that's why we are just discussing this on a larger scale. But what I'm trying to say is whether those who had claimed the refund, because they did not get the refund, but whether in their claim form they are also seeking allotment of the unit or they are only seeking refund.
Sir, claim form is only about how much amount they have paid and what is the
Correct.
interest. It doesn't talk about that what will come because
No,
nobody
no,
knows whether it.
in the claim category, they also seek like possession of their unit. They mention that also. Along with the amount, of course, whatever they have paid and whatever amount with the interest they calculate, but also they say about the unit. They mention about the unit also, right? So
No,
what I'm trying to say is because see, ultimately our resolution plan will always offer in relation to admitted claims. They will the resolution plan will also give options. Those who want to seek refund of their claim amount, they will be paid so much amount, maybe 80% of the claimed amount, or 100% or 50%. Second option will be that they will be allotted a project subject to payment of certain charges. RA will say that. Now, the issue that we are discussing is whether the RA can take create three different categories and
absolutely,
treat
absolutely.
differently in a resolution plan.
Yeah,
I
can
don't
he
see.
give one or more treatments to different people? That is what is the question. Because
Correct,
the
correct,
home buyers inter se also there some of them are saying that they should not be treated equal to me like that.
correct. So, but then perhaps the resolution plan will definitely, in any which case, in whatever categories he will define, the resolution applicant will definitely give options to all three categories. Either to seek
Okay.
refund, that option will definitely be there. So I don't see any problem in creation of categories for this purpose because cancelled allotments. But then I personally feel that cancelled allotments and the ones whose allotments are not cancelled and installments paid, they should be treated in one category.
Okay.
But the ones who had already sought refund, they may be taken into a different category. But it's all very subjective. I mean,
Yeah,
after
yeah.
seeing through, scrutinizing each and every fact. But then, because allotments which are cancelled by the builder, it is also an admitted case that the builder has not repaid them back. So perhaps if an option is given to them also to take possession of the disputed unit upon payment of some amount, then I believe that can also be exercised. I mean, they should not be left out because they also did not get a chance to oppose the cancellation of their allotment and before that also perhaps CRP might have happened. So in such a case scenario, perhaps the first two categories perhaps should be taken into one.
Okay, sir.
Ji.
Apoorv
That's my own personal view. I mean, we can have a different opinion also, but perhaps all this is very subjective. Yes. Ji, sir.
Yeah, Apoorv just two things which I wanted to say. One is this regulation 13(1)(c), now it allows these belated claims. Like if there are
Correct.
belated claims beyond the statutory period, claims which
Correct.
are coming. So RP has to collate that and put up to COC members, and then post recommendation of COC members, it has to go to NCLT AA for its approval. So now belated claims have to be taken as per this regulation 13(1)(c). That is a new thing which has come in. And second thing is that even IM provisions are there that where the creators who have not filed their claims, you have to file a list of attach such list in your IM information memorandum, that
Yes, yes,
list of
yes.
creators who have not filed claims. So in both the cases, the RA is aware ki what is happening, like what he
Correct,
has to
correct.
take care. He's aware of the belated claims, and he's also aware of the list of creators who have not filed claims.
Correct, correct, sir, correct. That is true. That is true. But perhaps we don't know. I mean, sometimes taking charge of the assets, how much RP is able to take charge, how much IRP is able to take the records of each and every home buyer. So,
Yeah, you
uh,
have to take. You see, if the CD is
uh,
not cooperating, then naturally you will be in difficult position. But if the CD is
yes,
cooperating, his CD is giving you the details of the creators as per the books, and you also know that okay, as an RP, you know that who are among these creators who have filed the claims and who have not filed the claims. So you can segregate like these are the creditors who have not filed their claims, and that
yes.
will
I
form
don't
part
know.
of
I
the
don't
list.
know when that if has come out to be true in the last 10 years. That if that CD has given the details. So, but
Yeah.
anyways, but you're right, sir. You're
Mm,
absolutely right. I mean,
mm.
there is an amendment. There was an amendment. So, till the approval of resolution plan, whatever claims which have
Yes,
been
correct.
verified, which have been collated and admitted, they should be treated as part of the resolution plan. That
Right.
90-day thing is a nine.
Yeah. Yes.
I think
It
90
is.
days. Then there was an amendment that till RFRP, whatever claims have been filed have to be admitted, and then
Uh,
after that, till approval of resolution plan. So
yes.
those
Yes.
amendments are there.
Yes.
And second is, of course, IM has to provide all the information. So even
Yes.
if the claims are not filed, such list is there available with the RA.
Yes.
And that is
Correct.
what Puneet Kaur NCLAT has held. So they were already there. So
Yes.
they should provide they should give a provision. They should make some provision. So our resolution applicant should make a provision because
Yes.
just because of non-filing of a claim when the record is already there. If the record is also not there, then it's a different issue,
Yes.
perhaps.
Yes.
But then if the
True.
record is there, then perhaps such benefit should be given to the allottee.
Correct.
And that's
Correct.
the entire intention. I mean, the
Yes.
intention of this IBC should not be that those who don't file claims, their claims should just vanish, even if
Yes.
the record is available, that such claims do exist. And that's why perhaps there were more amendments because initially, if you all remember, IRP did not need to write to the government departments, but after
Yeah.
the
Yeah.
amendment to the CRP regulations, only the IRP was, I mean, it was another duty added in the IRP's duties that he has to approach all the government departments to tell them that, look, if any claim is there, this company is in CIRP. So you file a claim, be it electricity dues, be it EPFO dues, be it everything. So,
Yes.
so which means sanctity to something which is already there on record. IBC wants to protect that sanctity, wants to honor such sanctity of such records. It is not just to intention can never be that those who are not filing claims they should just vanish. I mean, ultimately, somebody has paid to the corporate debtor. At least that chance needs to be given to revive his claim or whatever it is. He should get the results of whatever he invested in the company. So, uh, so this is again Supreme Court. Of course, home buyers hold a special place. in IBC jurisdiction. They are treated more. What do you say? They have those what you call brownie points towards the judicial forum. All the judicial fora, they have those. They don't need to plead much. They just have to show that their equities for them available for them, and courts are have favored. So even such cases where, if you see, even in this case, 60 lakhs, but 3 lakhs was a default on behalf of home buyer also. But even in such cases, possession was directed to be handed over to the uh, allottee within 2 months. So even if there is a minor default, that has also been taken care of by the courts. So any questions, any doubts before we move to the next case, the fourth one? So the fourth one is Electro Steel Limited versus Ispat Carrier Private Limited. So it was delivered in April 2025, 7 SCC 773. This is an SCC citation. Now, what were the facts? The respondent here was an operational creditor which had initiated proceedings before the MSME Facilitation Council, which is the Micro, Small, Medium Enterprises Facilitation Council, for recovery of its dues prior to initiation of CRP against the corporate debtor. During the pendency of such proceedings, CRP was initiated under Section 7 of the Code, and a resolution plan was submitted, wherein claims of all OCs were settled at nil. So the claim of this particular operational creditor was also settled at nil in the resolution plan. The resolution plan was approved by the NCLT under Section 31 on 17th April 2018, declaring that the moratorium under Section 14 would cease to exist and that the plan would be binding on all stakeholders. That is important. Plan would be binding on all stakeholders after lifting of the moratorium. The Facilitation Council resumed arbitration proceedings and passed an award in favor of the respondent OC, which led to execution proceedings being initiated, giving rise to the present dispute. So, just to clarify the facts, there was an OC and which had initiated MSME proceedings against the CD. CD was under CRP in some other Section 7 application where this particular OC's claim was also admitted but was settled at nil in the resolution plan. After the moratorium was ceased to have effect after the approval of resolution plan, the MSME Facilitation Council continued with the arbitration, and then award was passed in relation to the same OC. Now, after the award was passed, execution petition was filed by the operational creditor before the concerned executing court. Now, here the issues were whether upon approval of resolution plan by the NCLT, the claim of the respondent not forming part of the resolution plan stood extinguished, and whether the arbitral award passed after the approval of resolution plan was without jurisdiction and incapable of execution. Current legal position, Section 14, which is relating to moratorium, Section 30, subsection 2, requires the resolution plan to comply with statutory conditions, including lawful treatment of claims and adherence to provisions of the code. Section 31, subsection 1, which provides for approval. Once the NCLT approves the resolution plan, it is binding on all stakeholders and it extinguishes all claims not forming part of the plan. Section 238, which is having overriding effect over other laws. Section 34 of the Arbitration Act and Section 36, read with Section 47 of CPC, which permit challenge and execution of arbitral awards, but also allow objections at the execution stage. So objection petitions were also filed before the executing court, where the award is held to be without jurisdiction or contrary to binding resolution plan. Relevant observations of the Supreme Court in relation to these two issues. Para 72, lifting of moratorium. It does not mean that the claim of the respondent would stand revived. So first, very important observation is that mere lifting of moratorium after the approval of resolution plan does not mean that all claims are revived, even if they are unpaid. So notwithstanding approval of resolution plan by the NCLT, moratorium is intended to ensure that no further demands are raised or adjudicated upon during the CIRP, so that the process can be proceeded with and concluded without further complications. View taken by the High Court cannot be accepted in the light of the clear-cut provisions of the code as well as the law laid down by this court. In view of the resolution plan as approved, the claim of the respondent stood extinguished. So, clear-cut observation that such a claim was extinguished after the acceptance of the resolution plan. Therefore, the Facilitation Council did not have jurisdiction to arbitrate on the said claim. Since the award was passed without jurisdiction, the same could be assailed in a proceeding under Section 47 of CPC. Section 47 CPC is relating to filing of objection petitions before the executing court. So so an award can be assailed if it is without jurisdiction. That is what the Supreme Court held. View taken by the High Court. So in this case, what the High Court has held was that because the appellant did not challenge the arbitral award under Section 34 of the Arbitration Act, therefore it was precluded from objecting to the execution of the award at the stage of Section 47 of CPC. So that view was held to be, of the High Court, was held to be unsustainable. Consequently, the view taken by the High Court that notwithstanding approval of resolution plan by NCLT, the Facilitation Council did not lose jurisdiction to proceed and pronounced the award is erroneous. So the High Court's observations were held to be erroneous in this case and contrary to the law laid down by this court, which is Supreme Court. And in that view of the matter, Supreme Court held that it has no hesitation to hold that upon approval of the resolution plan by NCLT, the claim of the respondent being outside the purview of a resolution plan stood extinguished. So, a very interesting case that even after the resolution plan where the debt, the claim was taken care of, though nil amount was received under the resolution plan, and the claim itself then stood extinguished post the approval of the resolution plan. Even in such, after that, MSME Council, Facilitation Council continued with the arbitration. The operational quarter also continued with the arbitration, and even an award was passed. And after the award was passed, an execution petition was also filed. So quite clearly contrary to the provisions of the code, because terms of the resolution plan are binding on all the stakeholders, that we all know. And that was not properly followed by the one of the stakeholder, which is the OC. Of course, he was aggrieved by the resolution plan, but correct way was not to continue with the proceedings, but maybe challenge the resolution plan at some level. That he did not do. Rather, he continued with the arbitration proceedings. So that was the fault. So Supreme Court has rightly understood the situation that in such cases, neither the MSME Facilitation Council can continue with arbitration because the plan took care of the claim of the operational director. Though it did not award him anything, but it took care. And so it extinguishes the debt. And there was no need for adjudication. And second, also, then in such case, ultimately, OC was aggrieved, then he was aggrieved, he should have taken recourse to proper legal proceedings, which he did not do. Though such observations are not coming, these are my own thoughts on the issue. That what he could have done was to challenge the resolution plan, maybe at that level, that maybe if he could have succeeded there, but rather than going for it, rather than going for appealing against that, it went ahead and continued with arbitration, which is not permissible. So Supreme Court sets it right by holding that High Court was not right in dismissing an objection petition filed by the corporate debtors RA. which had held that such claims had already extinguished upon the approval of the resolution plan by the NCLT. So, any questions or doubts in this?
Apoorv, just I'm trying to think aloud. Something related to this only is say in a resolution plan there are say 10 operational creditors, and the
Right.
resolution applicant feels that out of those 10 operational creditors, there are 2 or 3 of them who are very important for the resolution applicant in future, say for doing business. And he says that, okay, can he be choosy? Like he can say that out of these 10, I will pay 3 of them some amount and I'll not pay anything to the balance 7. Is that type of thing permissible?
I think well, I believe the code itself answer is because resolution plan first, NCLT has to take care of this situation first.
Yes.
NCLT has to approve such a resolution plan. NCLT usually, you see with experience, you also must have seen that NCLT usually first thing that comes from NCLT while taking up such applications, plan approval applications, is to see whether how are OCs satisfied.
Hmm.
So this is what because they know FCs are on record, they are part of COC. So a resolution plan is approved by the COC. So FC's interests is taken care of by the FCs themselves. As far as OC is concerned, adjudicating authorities are there. So, but I mean, in practice also, I have seen many cases where NCLT itself has insisted upon the resolution applicant to take care of certain OC's claims, which are good, which are of good value, and even workmen also. Workmen, employees, their statutory dues, they have insisted upon the resolution applicant. And resolution applicant has, upon their oral assistance itself, modified the resolution plan, and also maybe increased the claim amount. If he is giving nil or if he is giving a less amount, then has increased that amount to a respectable level. That has been my own observations from the last 7, 8 years, 9 years, whatever I've seen. But um, you are right. I mean, code is quite silent on this.
Yes. Code is quite silent. Like it is
So
like
code is
RA
silent
can choose this
because
type of thing.
right. So code is silent because I again say perhaps intention of the parliament while enacting the code. First, it was an experiment, 2016 when it came, a very drastic experiment because here before IBC everybody is entitled to their claims subject to whatever charge and all the banks have, etc. On the remaining assets, everyone is entitled. Whoever approaches the court first gets his orders executed first, gets the claim, gets his dues. Others don't. But to that, the code has remained silent, maybe because by framing too many rules, it cannot take care of all eventualities in any which case. So perhaps left it to the commercial wisdom of banks first. But of
Yes.
course, banks won't take care.
Banks
Banks
won't take it, no? Banks may
Banks
even
won't
say,
take, yeah, banks won't take care of OC's interests, but then NCLTs are there, and that's what I have seen. I mean, NCLT's first question that comes is, how are you satisfying employees and OC's claims? Just tell me first. That's that has been the approach, and they see if the reduction of the claim amount admitted, and that also admitted claim amount, is drastic, then they have insisted upon the RAs to either increase the resolution applicant the RA's amount itself in the resolution plan's amount, or maybe upon the equitable distribution. They have suggested, and perhaps RAs have modified the plans to that extent in consultation and in consent with the COC members also.
COC, yes, yes.
Correct. So, but what I'm trying to say is that code is silent, but perhaps deliberately left silent uh, because if perhaps there can be cases where fraudulent claims also do come at the instance of the promoters, treating this, calling themselves as
Yes, yes, yes.
calling
Could be.
themselves as operational creditors.
Yeah.
So, because we all know that, I mean, ground reality is very different. In practice, many OC's claims are at the behest of promoters. We all know. I mean, siphoning off and how such money is treated as that OC is also a promoter. So we all know. So, I mean, there can't be a hard, clear-cut formula. I mean, hard and fast rule that all OCs have to be paid. So I believe adjudicating authorities have done right to some extent, whatever I have seen. That I mean, where there are operational creditors which are like there are operational creditors which are statutory authorities also. I mean,
Yes.
some industrial corporation, let's say RICO is there, uh, or DSIDC. I mean,
Yeah, even
there are
power dues also.
our dues and all. Yes, that is also there. But what I'm saying, OCs, I mean, PSU's claims are there, established entities claims are there,
Yes.
and good amount of claims. So I have seen, I mean, though I've also seen that initial resolution plan would definitely award them lower amount in relation to what is being admitted. I mean, maybe very, very meager amount. And COCs don't care. They just want their own money. But
Yes.
I believe NCLTs have first question that comes is how are you satisfying OC's claims? And then they see. I mean, the list is with before them. They see everything. What kind of category of OC is this? It's an established one. Uh, so I believe. Of course, I mean, it's a bit hard on OCs because they don't have a proper. I mean, but then having a good rule towards OC is also subjected to misuse by the promoters. That is perhaps the intention. Perhaps legislature already knew the ground realities that in such cases wherever there are financial defaults, mostly cases are financial defaults. Let us all so in such cases financial defaults in the sense they are loan defaults is what I'm trying to
Yes.
say.
Yes.
So in such cases they all know, I mean, most of cases these are willful defaults of fraud accounts where there is siphoning of funds through such a medium that the promoter will involve his own entity as an operational creditor and show some fake sale purchase transactions also. Now those fake sale purchase transactions also qualify to be OC debt.
OC. Yeah, yeah. True.
Yeah, so how much as if we also tend to sympathize with OCs, we
Mm.
also need to understand that sympathy might lead to uh, the promoter, ultimately deriving all the benefits
Yeah, quite
for the
possible.
different end.
Very much possible.
So, so all those things have to be taken care of. I mean, all things are not written in black and white here in the code, and that's why we are discussing. So that's why I'm saying. So my own personal view is adjudicating authorities have taken care of such, you'll say, inequitable treatment to OCs. Because as you say, rightly said, that out of 8 or 10, if RA chooses, I will only give money to two and exclude six.
Mm.
NCLT's first task, and I've seen they raising amounts in the resolution plan to include satisfy the OC debts at a respectable figure. Of course, they will definitely never get 100%. Nobody
Mm.
gets, but even the FCs don't get. But
Mm.
whatever it is, it's now at least it's better than nothing. So, any other questions or any point of discussion? Someone want to add anything on what Rakesh ji and I have been discussing?
Yeah.
Any further experience on this? See, ultimately, coming back to the case, this was about uh, MSME Facilitation Council is an organ of the government. We all know that. So, Facilitation Council, it's in Delhi. It is the SDM office where all the facilitation councils are there, and now, if the government authorities, even after acceptance of resolution plan, they go ahead and arbitrate a matter and then pass an award when the resolution plan is already approved in relation to the same claim which was there covered under the resolution plan. So in such a that is something which should be taken seriously, because ultimately what the corporate debtors resolution of SRA had to do, that award was passed, execution was filed. I mean, they are going to execute the award also. And then the SRA, after acceptance of resolution plan, after giving some money for the resolution of the corporate debtor, he has to then go ahead, challenge this award. You know, I mean, he has to again expenses on litigation expenses
Yeah,
and everything.
experience
All these
expenses
adds
are.
up. So ultimately, I mean, if such situations are allowed, then more and more people will tend to not get into the resolution aspect. I mean, all this will lead to liquidation for because uncertainties will always remain. So in
Mhm.
that respect, the judgment is welcoming one, especially. But then statutory authority going out against the IBC provisions. Of course, operational creditor will definitely insist because he will not get anything, and other he did not get anything in the resolution plan, but he did not opt for the proper remedy. Maybe he would have succeeded, maybe his appeal would have been dismissed against the NCLT's resolution plan approval order, but then that was the only course he had. He could not have independently initiated proceedings which were already under moratorium by stating that moratorium is gone, now I will have an award in my favor and execute it against the SRA. So that can't be the intention of the court. If that is the intention, then what's the point of having inviting claims before the RP and then having a common resolution plan? What's the point of resolution if it is not treated as a resolution? So that's the whole that is the whole object of the code, which needs to be appreciated by everyone. So even those, so that another thing that is important is that awareness of IBC at such a level that even MSME Facilitation Council, that officers there who are there, they should be aware. Of course, lack of awareness is another thing which is leading to such kind of situations where the courts ultimately have to, and quite even the High Court itself had favored in favor of the award holder. So quite remarkable. I mean, this SRA had to go to the Supreme Court.
Supreme Court. Yeah.
How it is. So these are
No,
situations which will
correct.
definitely create a negative impact on the market to the extent that IBC will lead to uncertainties. So this is the resolution plan amount is not the end of the matter. RA still has to bear some brunt out of some other independent parallel proceedings that might continue forever. So this is resisting the resolution. This is approach is resisting the chances of resolution in any IBC CRP process. So we are done with 4 cases, and we'll take a short break of 10 minutes, and then we'll come back. And we'll be left with another 4 cases. So
Yes.
I hope everyone is enjoying till now this
Yes. Yes.
session. What I'm talking
Okay.
about.
Certainly. Certainly.
Right. Okay, sir. We'll take 5 to 10 minute break. We'll take and we'll join by 3:50.
क्या खाएगा ये खा लेंगे नहीं चला
भाई कैसे चक्कर से
फोन है ना अपना
Yeah, so welcome back. We'll restart the session.
Thank you.
So we have already discussed the first four cases of our today's presentation. Now we are going to deal with our fifth case, which is Kalyani Transco versus Bhushan Power and Steel Limited. This is a September 2025 judgment with neutral citation 2025 INSC 1164. The facts of this case, this is relating to the famous Bhushan Power and Steel CRP. So Bhushan Power, it admitted into the CRP into July 2017 on an application filed by PNB under Section 7 of the Code. During CRP, JSW Steels Limited submitted a resolution plan which was approved by the Committee of Raters and thereafter approved by the NCLT New Delhi in September 2019. We all know about this, and under Section 31 of the Code, appeals filed by the OCs. So appeals were filed by the operational creditors, including Kalyani Transco, which is one of the appellants here, which is the appellant, and the suspended directors were dismissed by the NCLAT on 17th February 2020. So the appeals filed against the approval of resolution plan were dismissed in February 2020 by the NCLAT. Aggrieved, the appellants approached the Supreme Court challenging the validity of the resolution plan and the orders of the NCLT and NCLAT on the ground of non-compliance with mandatory provisions of IBC. So, yeah, so the mandatory provisions. So now issues before the Supreme Court were whether the resolution plan, which was approved by the adjudicating authority and affirmed by the NCLAT, complied with the mandatory requirements of 29A and subsection 2 of section 30 of the IBC, read with regulation 38 of the CIRP regulations. And the second was that whether the CIRP and approval of the resolution plan were vitiated due to non-adherence to the mandatory timeline prescribed under the section 12 of the code. Relevant statutory provisions, section 7, we all know. Section 12 is about timelines under the CIRP, extendable only in the manner provided under the code. 29A disqualifies certain persons, including defaulting promoters and related parties, from submitting a resolution plan. And 30 subsection 2 sets out mandatory statutory requirements that a resolution plan must satisfy before approval. 31 provides for approval of resolution plan. 32A, it grants immunity to the CD and its assets from prior offences after approval of a resolution plan, subject to conditions. 33 mandates liquidation of the corporate debtor where no valid resolution plan is approved or where CIRP fails. 61 and 62, it provides for the appellate framework, we all know. Then regulation 38 CIRP regulation, it prescribes statutory mandatory contents of a resolution plan, including priority of payments and fair treatment of creditors. Now, relevant observations of the Supreme Court in this, and all relating to the two issues, that whether 29A and 32 requirements were followed and regulation 38 were followed, and then about the non-adherence to the mandatory timeline procedure. So Supreme Court holds that the very purpose for which the IBC was enacted, to ensure that CD continues as a going concern, has not only been achieved. So it lauds the resolution in this case, but the corporator has been transformed from a loss-making to a profit-making entity. If after the implementation of resolution plan, the SRA, which is JSW, has converted a loss-making entity into one profit-making entity, can it be penalized for that? Suppose if instead of CD being converted into a profit-making entity, the losses would have increased, can the corporate debtor claim refund of the amount paid? If we permit the claim not to be part of the resolution plan, which has been approved by COC and NCLT to be raised at such a later stage, it could open a Pandora's box, and the very purpose of IBC providing sanctity to the finality of the resolution plan duly approved would stand vitiated. In any case, the issue is no more res integria. This court, in the case of Supreme Court in SR Steel, has held that such could not have been the intention of legislature, as this would amount to Hydra heads popping up after the approval of the resolution plan. It has been categorically held that the SRA cannot be forced to deal with claims that are not a part of the RFRP issued in terms of section 25 of the code. So this is important. It was said that SRA cannot be forced to deal with the claims that are not a part of RFRP in terms of section 25 or part of its resolution plan. So no doubt that if RFRP had specifically dealt with the manner in which these EBITDA claims would be distributed, it would have been a different matter. So RFRP itself did not seek such a requirement. So that's why, if had there been a requirement under the RFRP document that the resolution plan must also make provision for the EBITDA payments, then it was a different case scenario. That is what the Supreme Court is holding. In the present case, neither the RFRP nor the resolution plan dealt with it, permitting the erstwhile promoters or the COC to raise an argument in that regard at such a belated stage would amount to doing violence to the very intention with which the code was enacted. We therefore do not find any merit in the contention of either the ex-promoters from directors or the CD in that regard, if such contention is accepted, it will frustrate the very purpose for which the IBC came to be enacted. In that view of the matter, we do not find any merits in the appeals. The appeals are therefore dismissed. So, ultimately, the requirement under the resolution plan to provide for dealing with the requirement under Section 29A and then relating to the Regulation 38, that whether the resolution plan contained provisions relating to satisfaction of certain claims. Since the RFRP document, which is made by the RP only in consultation with the COC, so if that document does not contain such a requirement, then the Supreme Court says that at the stage where now that JSW has now been successfully running the CD after taking over the corporate debtor, Bhushan Steel, and now it has also made it a profit earning entity. At this stage, if we are allowed to accept such an argument, then it will be a clear injustice to the court. I mean, the entire process which has been followed. So, in such a case, this contention was not appreciated by the court, that the resolution plan must provide a particular thing, which was neither a requirement under the RFRP document. So, that is the crucial part of the reasoning given by the Supreme Court, that the RFRP document needs to, if RFRP document had mandated a particular requirement which was not followed in the resolution plan, while giving the resolution plan, then it would have been a very different thing. So that is an important observation, that even for making a challenge to a resolution plan, there has to be, this also has to be scrutinized, that the RFRP document had mandated providing a particular provision relating to satisfaction of certain distributions, in this case the EBITDA claims. So that was not there. So then the resolution applicant has to be given that benefit, also given the fact that it has made profits after taking control of the corporate debtor. Any point to discuss? Any, or is it understood? Everyone, is there any question or doubt? Shall we proceed with the next case?
Yes, this is clear. In fact, this was, I think, necessarily some claimants wanting to argue after 5 years, passing of the resolution plan that UPA might use and all that.
Yeah, so the promoters themselves, they wanted to challenge the resolution plan and some operational creditor,
Yes.
that some claims were not taken care of in the resolution plan, or the manner of dealing with such claims. So which was not even a requirement under the RFRP.
Yes. So,
I think,
no, very rightly done by Supreme Court. There's no doubt.
right. So, I mean, the Bhushan Steel has a background, we all know. Earlier in the year, also, Supreme Court had recalled its resolution, then again recalled its own order after
Yes.
the retirement of one of the judges. When Justice Gawai took over, it again recalled its own observations. And then
Yes.
later, this judgment came. So, ultimately, I mean, we all know the background. This is one of the 12 biggest accounts, default
True.
accounts, which were there.
Dirty doesn't. Yeah, dirty
So
doesn't.
certainly, I mean, and when there is already a resolution and the entity has made profits after the resolution plan being approved, after that, so when SRA does such a good job, at least in terms of making it functional, I mean, this is a case which is one of the successful, which should be taken as one of the successful cases of one of the biggest projects, one of the biggest defaults, and instead of that, reversing the entire IBC process, or reversing everything which has been done by all the participants, be it the RP, the COCs, the banks, everybody, I mean, would have been a setback. So given that background also, Supreme Court took a right view. Now, next case is Mansi Brar Fernandez versus Shubha Sharma. September 2025 judgment. Neutral citation 2025 INSC 111110. In this case, very interesting this one also. The appellant, another related to projects. The appellant is Mansi Bra Fernandez. She had entered into an agreement with the CD for purchase of a residential unit and had paid substantial consideration. On default by the CD, CIRP was initiated under the code. The appellant submitted her claim as a home buyer and financial creditor during CIRP, which was taken note of in the resolution process. However, disputes arose regarding the nature, treatment, and enforceability of the appellant's rights under the approved resolution plan, leading to proceedings before the NCLT and appellate authority, which culminated in the appeal before the Supreme Court. So the issue before the nature of claim was that whether the appellants they fall within the category of speculative investors, so as to disentitle them from initiating proceedings under Section 7 of the Code. Also, the Ordinance and Amendment Act of the Code, which introduced threshold requirements for filing of Section 7 IBC applications by allottees, whether that was applicable to the facts of the present case. So in this case, relevant legal provisions, Section 58F, which is about clarifying that any amount raised from an allottee in a real estate project is deemed to be financial debt, and Section 18 and 25, which obligate IRP to receive, verify, collate claims. 31 of the code, which is about plan approval and making it binding on all the creditors and stakeholders. And then Section 238 is the overriding effect of the code. Now, the relevant observations of the Supreme Court judgment. They first dealt with the definition of speculation as made in Ramnath Iyer's law lexicon, by holding it as a risky investment of money for the sake of and in expectation of unusually large profits. A speculator is one who practices speculation in trade or business. So two elements emerge. First is expectation of unusually high profits. So that is part of speculation. Second is activity in the nature of business or trade. These elements accord with the ratio of Pioneer Urban, which described speculative investors as those seeking refund or profit without an intention to occupy. Pioneer Urban, we all know, is that judgment where home buyers were treated as FCs. So there, the speculative investors who are seeking refund or profit without an intention to occupy, they were held to be different from home buyers. So thus, where there is an actual chain of delivery ending with possession by a genuine buyer, the transaction is not speculative. So ultimately, the test is whether the creditor is intending to take possession of the unit or not. Conversely, in the present context, where there is no intent to take possession, no intention, the onus to find another buyer and effect resale is cast on the developer. So onus to find another buyer and effect resale, that is also cast on the developer. Delivery in such cases is more in the nature of a lien or an option. For a genuine allottee, however, delivery and possession are a sine qua non, which is essential. So genuine allottee will definitely take possession of the unit, but where there is speculative investment in the market, then in such cases, the builder developer itself suggests that he will ensure that he will bind another buyer and effect resale. So, which means that intention was never to occupy the premises. Then such a person cannot be treated to be a home buyer, but a speculative investor. So, then non-exhaustive 18.4.5 non-exhaustive indicators include if the agreement substitutes possession with a buyback or refund option, or any other special arrangement, the allottee is likely a speculative investor. Insistence on refund with high interest, coupled with the refusal to accept possession, would indicate speculation. So, purchase of multiple units, especially in double digits, shall invite greater scrutiny, though it is not conclusive. If the terms of agreement provide for possession or refund in the event of failure to give possession alone, this factor may not be held against the allottee. Special rights, preferential treatment, or unusual privileges to the allottee would signal investment intent. Deviation from RERA model agreement shall be a crucial indicator as to the nature of the transaction. The greater the departure, the greater the likelihood of speculation. Unrealistic interest rates and promises of 20 to 25% returns over a short duration are indicative of speculation. So Supreme Court has included many indicators which shows that how a particular investment would be called speculative rather than being a genuine case of a home buyer allotment. So then however, it must be clarified that the distinction between speculative investors and genuine home buyers is relevant only at the stage of initiation of CRP. So they have clarified that this distinction is requirement only for scrutinizing at the initiation of CRP, whether a home buyer is actually come to NCLT or not. Such allottees are not barred from filing claims. So even speculative allottees, they are not barred from filing claims for the principal amount invested. So relevant is principal amount or from pursuing remedies before other fora in accordance with law. Then now reference to the ordinance of 2019, which ultimately became the Amendment Act also, that which added a proviso to subsection 1 of section 7, that before the explanation, providing a threshold limit for initiation of CRP at the instance of allottees under a real estate project. It mandated that an application shall be filed jointly by not less than 100 allottees or not less than 10% of total number of such allottees under the same real estate project, whichever is less. It further provided that where an application for initiating CRP against a CD had been filed by such financial creditors and had not been admitted by NCLT before the commencement of the IBC Amendment Act 2020, such application was required to be modified to comply with the requirement. So the requirement of 10% or 100 allottees, whichever is there, within 30 days of the commencement of the Amendment Act, failing which it would be deemed to be withdrawn before its admission. Accordingly, the outcome on grounds of equity should be determined as on the date the order was reserved and no subsequent legislative or administrative change should prejudice the parties. In conclusion, while the validity of the threshold requirement introduced by the ordinance has been upheld by the court in Manish Kumar vs. Union of India, its application must necessarily depend on the stage of proceedings and the feasibility of compliance. Where So the requirements were upheld by Manish Kumar in Supreme Court only. Where orders were already reserved prior to promulgation of ordinance, the requirement cannot be retrospectively enforced so as to defeat vested rights. The subsequent compliance by the appellant during appellate proceedings sufficiently cures the defect, and the act of the court must not prejudice the litigant. Therefore, the finding of the NCLAT in respect of inapplicability of ordinance to the facts of the present case requires interference, and the first impugned order deserves to be set aside to that effect. Accordingly, this issue is answered by us. Now, after this, Supreme Court talks about the constitutional obligation of the state to protect home buyers. And so here it talks about Article 21 of the Constitution, which deals with right to life and liberty. And in such cases, even right to shelter has been recognized as a part of Article 21, a fundamental right, and also makes reference to various welfare schemes such as Pradhan Mantri Awas Yojana, etc. Then also makes an observation that a home is not merely a roof over one's head, it's a reflection of one's hopes and dreams. So then the plight of also discusses the tax-paying middle-class citizens, their plight, and if their projects, their investments go in vain, then it's a disheartening picture for them. So observations relating to the state of home buyers in such cases where the matter is going to CIRP. Then it says in 20.4, it would be thoroughly erroneous to treat home buying as a mere commercial transaction, or worse, to reduce housing to the status of speculative instruments such as stocks, debentures, futures, through creative contractual devices. Housing is neither a luxury nor a commodity for speculation. It is a fundamental human need. So the state carries a constitutional obligation to create and strictly enforce a framework where no developer is permitted to defraud or exploit home buyers. Then it talks about the comparative experience from Western countries to demonstrate the dangers of unchecked speculation. And despite smaller populations, several nations face acute housing shortages, prompting measures such as restrictions on the number of houses an individual may own. India must ensure through robust policies and strict enforcement that such a crisis never arises here. And then it makes reference to recent amendments and regulatory measures and merits recommendation for undertaking proactive structural reforms. Much remains to be done. It is imperative that RERA authorities are not reduced to toothless tigers. So it also talks about RERA, that RERA should not remain toothless. They must be equipped with adequate infrastructure, empowered tribunals, and effective enforcement mechanism so that their orders are implemented swiftly in letter and spirit. Only then can the constitutional promise of right to shelter be meaningfully realized. Now, the court issues some guidelines. So some directions are issued to the authorities in the larger interest of bona fide home buyers and stability of real estate sector, which demand coordinated action by the stakeholders. So first is vacancies in NCLT and CLAT that shall be fulfilled on a war footing, dedicated IBC benches where additional strength should be constituted, retired judges' services to be utilized on an ad hoc basis until regular appointments are made. So it also makes reference to its own similar directions in Pioneer Urban case, which has not been, but no steps have been taken on ground. Then the union government, it has directed to file a compliance report within 3 months on measures taken to upgrade NCLAT NCLT infrastructure nationwide. The recent closure of Chandigarh NCLT and portions of Delhi NCLT due to water seepage in courtrooms and chambers of members underscores the urgency of robust infrastructural support. So then within 3 months, a committee chaired by a retired High Court judge shall be constituted with the representatives from Ministry of Law, domain experts in rare, and so all the industry representatives. That committee will suggest commercially viable systemic reforms for cleansing and infusing credibility into real estate sector. And then state to ensure that RERA authorities are adequately staffed with infrastructure, experts, resources. So even RERA is also there in guidelines, not just NCLT. But then since real estate is second largest in IBC proceedings, IBBI shall constitute a council to frame specific guidelines for insolvency proceedings in real estate, including timelines for project-wise CIRP and safeguards for allottees. Then there is a resolution of real estate insolvency should, as a rule, proceed on a project-specific basis rather than the entire corporate debtor, unless circumstances justify otherwise. This would protect solvent projects. So project-specific basis, that requirement is there. And genuine home buyers from collateral prejudice, they should not be, because of some other project falling, so the entire CD should not go into insolvency. That is the interval. Then IBBI shall also devise a mechanism to enable handover of possession to willing allottees where substantial units in a project are complete. So a lot of directions, a lot of guidelines. Then the union government shall consider establishing a revival fund under NARCIL or expanding the Swami fund to provide bridge financing for stressed projects undergoing CIRP. thereby preventing liquidation of viable projects and safeguarding homebuyer interests. Yes. Swami Fund is commendable initiative. However, being a large fund involving public money, every rupee must be utilized strictly for its intended purpose of last mile financing. To prevent misuse, we direct that a comprehensive periodic performance audit by CAB be carried out. So, a lot of directions, then regulations shall ensure meaningful representation of lotteries in COC through authorized representatives with safeguards against conflicts of interest, which is important, which we usually see also in RERA project, in real estate projects. A lot of groups become active when there are FCICs involved. So, so there should be safeguard to against conflict of interest. So they have ensured meaningful representation of lotteries. Then at the admission stage of Section 7 petitions filed by lotteries, NCLTs must record a prima facie finding on whether the applicant is a genuine home buyer or speculative investor. This would prevent unnecessary admission and reduce docket burden. So even if a speculative investor tries to initiate insolvency proceedings, then that is also harmful to the project. That's what he's trying to say. The government shall prioritize e-filing, VCs, dedicated case management systems for IBC matters in view of heavy caseload before NCLTs, and every residential real estate transaction for new housing projects shall be registered with local revenue authorities upon payment of at least 20% of property cost by buyer allottee. So uh, then 20% payment is itself good enough for registration of the transaction for the authorities, revenue authorities. Then protection to senior citizens, bona fide home buyers, contracts that significantly deviate from the model RERA agreement, or that incorporate returns, buyback clauses where the allottees over the age of 50 must be supported by an affidavit sworn before the competent revenue authority certifying that the allottee understands the attendant risks. So these are all safeguards they have tried to ensure because they know that in such real estate matters, the home buyers are also playing in the hand of the developers. So extra caution in such cases. In projects at nascent stages, such as where land is yet to be acquired or construction has not commenced, proceeds from allottees shall be placed in an escrow account and disbursed in phases aligned with project purpose. So they've quietly directions are there very much to emphasize that there should be strict adherence to. I mean, there is no scope for the developer also to run away with the money of the home buyers. So, as per a RERA sanctioned SOP, so they are also calling for a RERA sanctioned SOP. Every RERA shall devise such SOPs within 6 months from today. So, and then future reforms, a lot of suggestions again. IBBI may consider introducing Basel-like early warning frameworks and drawing from comparative practices, pre-banking mediation, pre-bankruptcy mediation. So even mediation, they are talking preventive restructuring, requiring directors to initiate restructuring before defaults. We all know that under the new amendment bill, the creditors' insolvency uh, is already on the cards. So then union government should undertake a consultative exercise to bring about uniformity in RERA rules. So RERA is also there. Then housing board, state level, urban development authorities, they should have dedicated wings to revive and complete stall projects. So it's a matter of grave concern that despite funding hundreds of crores into various government-run think tank and management institutions as IIMs, IITs, India still require a robust homegrown consulting industry. So collaboration with India. So they are also into suggestions relating to consultation in these projects. And Union government may consider establishing a body corporate on the lines of NARCIL. So NARCIL, we all know, it has taken over the big debts from the big banks, and now they are saying that to consider establishing a body corporate promoted by real estate construction focused PSUs or through public-private partnerships. So quite, I mean, many directions. Some are directions, 21.2 are directions, and then there are suggestions for, these are only suggestions, not directions. The so they have there are the directions and then there are suggestions, both. And so ultimately to ensure right to shelter, because Supreme Court has also taken stock of the situation that home buyers are not getting their due. And of course, we all know that we are all aware that after 5-6 years of CRP, also these projects are stuck. So a lot of directions are there. But ultimately, the issue relating to speculative investors, that was answered by saying that NCLTs need to be proactive in first understanding if a particular FC calls himself as home buyer is actually a speculative investor or a real or a home buyer in itself. And what for all that, the agreement needs to be looked into. If possession is the priority or money with extremely high interest rates or maybe extremely high profits. So, given this backdrop, the court goes into um and then this Section 7 IBC ordinance requirements and all. So, but ultimately, it talks about massive reforms in the real estate industry and about uh, ensuring that right to shelter being a fundamental right, and senior citizens whose investments are also there, they are not duped by the developers in stalled projects. So many directions and many suggestions given by the Supreme Court in this matter. This Mansi Bra Fernandez versus Shubha Sharma. This is the judgment. So I don't know how many of us were already aware of these directions, but a lot. And 3 months' time has been given. So I think this judgment was passed in September. So by 26th December, after this, perhaps Supreme Court will again hear this matter. So maybe in the next year. So we are already on the same date. So today is 26th December only. So 3 months have passed today. After this, we might likely see in January or February, perhaps Supreme Court taking further control of this matter. So interesting to see what happens. Anything to share in relation to this? Of course, there are so many things that have been stated by the directions, and um, I mean, right from NCLTs, they're working, and even I mean infrastructure issues, even in RERA also, that too. I mean, and then I mean quite all maybe overzealous with the sentiments of the home buyers, siding with them. So again, what I said initially also in our session. So siding with the home buyer sentiments, they have a special sympathy, brownie points. So anything anyone wants to discuss, or should we proceed
Yeah,
to the next?
Apoorvji, this why has Supreme Court chosen to give all these directions in this particular judgment?
Yeah, so some are directions, some are
General judgments, and these are very important. What Supreme Court has said is absolutely right, but
right.
then why to fix it with a particular judgment?
I think perhaps what has perhaps, see, it all depends on the judge. I mean, what was on his mind at that time? Maybe he was too overly sensitized with the plight. We all know. I mean,
Hmm.
CRP of real estate projects. I am seeing personally. I've been involved in many cases as a lawyer and even otherwise. That 5-6 years these projects are stuck even after going under CIRP. And we all know this is how many projects, some CRP commenced in 2019, some in 2020, some in 2018, and even till date, the end of December 25. I am saying so that no resolution plan, even if the resolution plan has come, in some the projects are stalled. So perhaps that taken stock of that situation, perhaps these are overambitious observations which have been made. But why this case? Maybe because there is a case where a distinction was made between a home buyer and a speculative investor. So speculative investor, when such people, maybe Supreme Court came across such kind of agreements which the developers get into, that they indulge into entering into such kind of speculative agreements with some people who call themselves home buyers, who are actually not home buyers in the real sense, because they don't want possession, they only want profits. So maybe taking care of that, that's such that wherever, see, when we talk about, I mean, even directions such as, holding an escrow account, making an escrow account, I mean, they've gone to that extent. Of
Yes.
course, I mean, these are, one may argue, these are kind of interference with the executive
Mm-hmm.
in the doctrine of separation of powers, we all know. So, I mean, they are being over ambitious, but perhaps these are all, some are directions, some are suggestions.
Yes.
Uh, so maybe they have maybe got a bit carried away with their own sentiments, but perhaps in the right perspective only, because even in CIRP, such projects are stalled. It's not as if we are yielding results even in 2-3 years time. So even
No,
after 5-6 years, these
it,
projects
it
are
is not easy. It is even in CRP,
not
it is
easy.
not
Correct,
easy
correct.
for RP to resolve
Not
so
correct for
easily.
RP. RP
Not
has
easy.
nothing to do,
Uh,
but perhaps what is merely in such projects, because thousands of home buyers' monies are being stuck in a real estate projects.
no, it is
And
true.
then
Absolutely true.
I
Absolutely true.
remember, I think after the directions passed in this course, because there was some recent development that ED had also, IBBI had brought in ED also, Enforcement Directorate, where
Mm.
there are ED attachments. So they had joint consultations, after which ED had agreed on a particular requirement of that RB can move an application, and then ED can also give its NOC towards the projects where the resolution plan is being approved. Though initially the ED's initial stand was that we are overriding IBC.
Yeah.
TMLA overrides IBC. But post the consultation with IBBI, I mean, there was some 2-3 months back, some
No,
recent
no, there
development.
is a circular. True, true. There is a circular on
Right,
undertaking for
that
the
is there.
properties attached by ED. There is a circular.
Right. So
IBPA
that
circular
is
is
there.
there. Yes.
So perhaps all those things happened not just because ED wanted to do it, but
Mm.
perhaps because this kind of matter was there before the courts. And maybe perhaps some observations were made. Some observations were also made earlier that the Supreme Court makes reference to. So, which also which this one, Manish Kumar versus Union of India, where, no, not Manish Kumar, some other observation it holds. Where it has said that such, but nothing has been, I mean, nothing is done on the ground to improve the situation. So, um, anyways, so perhaps that is why perhaps they wanted to just highlight, because ultimately, I think if you circulate these directions, perhaps you will find lakhs and lakhs of people, coming to you and with buying these sentiments. So, but yes, of course, why this case, we don't know, but maybe perhaps
Mm.
because of the difference that some people call themselves as home buyers and they are actually speculative
Mm.
investors.
Mm.
Though they are also investors, but we don't know. I mean, what kind of transactions the builder or the developer is
Mm.
actually getting into. We all know what kind of transactions they are actually entering into. So ultimately, money is lost of
Yes.
a common man, and which is a clear-cut violation of fundamental rights. So by this case also, but then highlighting it and taking it to the fundamental right level, Article
Mm.
21. So this is how it Supreme Court justified whatever directions it has issued, that they are actually part of right to shelter. So this is how it is. Anyways, so next case is seventh one, second last, penultimate one is Mohammed Enterprises Tanzania Limited versus Farooq Ali Khan, January 2025 judgment, 2025 INSC 1110. Here the CIRP was initiated against Associate Decor on 26th October 2018 at the instance of a FC. During CIRP, the RP issued the IM and resolution plans were considered and deliberated upon in multiple meetings of COC. In the adjourned 19th COC meeting held on 11 Feb 2020, the resolution plan submitted by Mohammed Enterprises was approved by 100% voting share of the COC, and the settlement proposal of the suspended director was rejected. Thereafter, despite availing remedies under the IBC and after a substantial delay of nearly 3 years, the suspended director approached the High Court under Article 226, challenging the COC meeting and approved resolution plan. So here the suspended director approaches the High Court, not the NCLT NCLAT route. The High Court entertained the writ petition and set aside the resolution plan on the ground of violation of principles of natural justice, leading to the present appeals before the Supreme Court. So the issue here was whether the High Court was justified in exercising writ jurisdiction under Article 226 to interdict CRB proceedings and set aside an approved resolution plan under the IBC, whether the delay and availability of efficacious statutory remedies under the IBC barred the writ petition filed by the suspended director. Legal provisions, we all know 226, Article 226, then Section 12A permits withdrawal of CRP, 29 relates to IM, 30, Section 30 is about submission consideration of resolution plan, Section 31 about binding effect of resolution plan, 65 about jurisdiction of NCLTs, IBBI CRP regulations that we all know. They are the procedural regulations framed by IBBI. So here, Supreme Court holds that the last point taken by Mr. Shyam Devan, who is the senior advocate, that there is no delay in approaching the High Court, must be rejected. The reason is this: the CIRP proceedings commenced on 26th October 2018. The sheet anchor of Mr. Devan's submission and also the justification for the High Court to assume jurisdiction on the ground that principles of natural justice violated when respondent number 1 was not given a notice before the 19th COC meeting occurred way back on 11th February 2020. However, jurisdiction of High Court was invoked 3 years later on 4th January 2023. The time gap between these two events, almost 3 years, the initiation and continuation of proceeding by Swamitva Consortium before the NCLT or the Supreme Court cannot lend any justification whatsoever in approaching the High Court so late. Further, it is also an admitted fact that on 6th October 22, R1 moved an interlocutory application before NCLT seeking rejection of resolution plan filed by the appellant. The grounds taken in the IA are the same as those in the appeal. It is not as if the High Court was unaware of respondent number 1 availing the statutory remedy under the code. At least on this ground, the High Court should have relegated R1 to the procedure under the code and permitted him to continue the remedy that he has chosen to adopt. We may hasten to add that it is not necessary for us to enter into the merits of the matter to examine the amount offered by R1 and to contrast with the offer made by the applicant. The jurisdiction on power of NCLT and adjudicating authority under 65C has been reiterated in SR Steel versus Satish Kumar Gupta and Gujarat Urja Vikas Nigam versus Amit Gupta. And it is important to note that CIRP proceedings, which commenced 6 years ago, and the resolution plan was approved in 2020, 4 years back. So, importance of concluding CIRP proceedings was highlighted by this court in KSK Mahanadi case, and it was held that unjustified interference with proceedings initiated under the court breaches the discipline of law. In view of the delay in approaching the High Court, particularly when respondent number 1 himself has initiated proceedings under the court, by filing IAS seeking similar relief. We are of the opinion that the High Court committed an error in entertaining the petition. So, apart from delay and latches, High Court should have noted IBC is a complete court in itself, and supervisory and judicial review powers vested in High Courts represent critical constitutional safeguards, yet their exercise demands rigorous scrutiny and judicious application. This was certainly not a case for High Court to interdict CRB proceedings under the code. And so the Supreme Court allows the appeal filed by the RA, successful RA, and holds that the High Court was not justified in exercising its jurisdiction. And delay and availability of efficacious remedy could certainly bar the writ petition. So these two issues are answered against the High Court's judgment, and that's why the orders were set aside. Any questions or any doubts in this? So, very important fact here is that 2018 CRP initiated 2020 resolution plan was approved. So even because of the High Court's High Court not only entertained the writ petition, but also set aside the resolution plan or the COC meeting under its jurisdiction, only on the ground that the promoter was not given a notice of the COC meeting. And the same ground was taken before the NCLT. So, Supreme Court has not appreciated the High Court's order in this regard. Okay, the last case now is Sarang Anil Kumar Agarwal versus Bhavesh Dheeraj Lal Sheth. Another 2025 INSC 314, March 2025 judgment. In this case, the present appeal arose from a final judgment of NCDRC. It's a consumer matter imposing 27 penalties on the appellant for failure to deliver possession of residential units to home buyers within the agreed timeline. So another real estate. The appellant, a real estate developer and proprietor of East and West, faced multiple consumer complaints alleging delay in possession, deficiency in services, and breach of contractual obligations. By judgment dated 10th August 2018, the NCDRC allowed the complaints, directed completion of construction, and handing over of possession, and imposed penalties under Section 27 of the Consumer Protection Act. So, upon failure to comply, execution proceedings were initiated by the home buyers. During pendency of execution, insolvency proceedings against the PG. So, this is a PG matter. Insolvency proceedings under Section 95 of the Code were initiated against the appellant as a personal guarantor, triggering an interim moratorium under Section 96 of IBC. Relying on this, the appellant sought a stay of execution proceedings before the NCDRC, which was rejected by order dated 7th February 2024, leading to the appeal before the Supreme Court. So the stay application filed by the promoter, personal guarantor in this case, was rejected by the NCDRC. Issue before the Supreme Court whether the execution of penalty orders passed by NCDRC can be stayed during the interim moratorium under Section 96 of the Code, and whether penalties imposed for non-compliance with consumer protection orders constitute debt within the meaning of IBC so as to attract the moratorium under Section 96. Because what is imposed here before by the NCDRC was penalty under the Consumer Protection Act. Legal provision, Section 27 of Consumer Protection Act, it provides for penalties, which include imprisonment and for failure to comply with consumer forum orders. Section 94, 95, and 96 deal with initiation of insolvency proceedings against individuals and personal guarantors and provide for an interim moratorium. We all know these provisions. Then Section 7915 defines excluded debts, which includes liabilities arising from fines, penalties, and damages imposed by courts or tribunals. Of course, this is only related to PG provisions, not CRP. Section 14, this is a moratorium that we all know, and contrasted with the narrower moratorium under Section 96. Now, Supreme Court judgment observations, we find that there is a fundamental distinction between civil and criminal proceedings concerning a debt moratorium. While civil proceedings are generally stayed under IBC provisions, criminal proceedings, including penalty enforcement, do not automatically fall within its ambit unless explicitly stated by law. Penalties imposed by NCDRC are regulatory in nature and arise due to non-compliance with consumer protection laws. They are distinct from debt recovery proceedings under the IBC. A moratorium under Section 96 is distinct from a corporate moratorium under Section 14 of the Code. Section 96 applies to individuals and personal guarantors and provides that during the moratorium period, any legal action or proceedings relating to any debt shall be deemed to have been stayed. However, it is pertinent to note that this provision applies only to debt as defined under the code and not to regulatory penalties imposed for non-compliance with consumer protection laws. A careful reading of the statutory scheme of the code suggests that penalties arising from regulatory infractions are not covered under the ambit of debt as envisioned under the code. The moratorium under Section 96 of the Code is intended to provide temporary relief to debtors by preventing certain proceedings against them during the resolution process. However, this protection is not absolute and does not extend to all categories of debts. The legislative intent behind the moratorium is to ensure that the debtor's assets are preserved for an efficient resolution process and to prevent creditors from taking unilateral actions that may frustrate the objective of insolvency proceedings. However, the statutory scheme of code makes it clear that the protection under the moratorium does not cover all forms of liabilities, particularly those classified as excluded debts under Section 79, subsection 15 of the code. And respondents have rightly contended that Section 94, subsection 3 of the code explicitly limits the scope of moratorium by carving out exceptions for certain categories of debts. Section 79, subsection 15 of the code defines excluded debts to include liabilities arising from fines imposed by courts or tribunals, damages for negligence or breach of obligation, maintenance liabilities, student loans, other prescribed debts. So this classification is based on the nature of such obligations, which are either statutory, penal, personal in nature, and therefore they do not form part of insolvency estate that can be discharged under the resolution process. In the present case, damages awarded by NCDRC arise from a consumer dispute where appellant has been held liable for deficiency in service. Such damages are not in the nature of ordinary contractual debts, but rather serve to compensate the consumers for loss suffered and to deter unethical business practices. Courts and tribunals exercise their statutory jurisdiction to award such damages, and these are distinct from purely financial debts that may be subject to restructuring under the code. Since such damages are covered under excluded debts, they do not get the benefit of moratorium, and their enforcement remains unaffected by initiation of insolvency proceedings. Further, the rationale behind excluding such liabilities from moratorium is rooted in public policy considerations. If damages arising from legal violations, consumer protection claims, or penalties imposed by courts and tribunals were to be shielded under the moratorium, it would create an unfair advantage for errant entities and individuals, allowing them to evade their legal obligations under the guise of insolvency. The IBC, being a special law meant to balance the interest of all stakeholders, does not intend to provide relief to those who have been held liable for statutory breaches or misconduct. So penalties, then it talks about the different penalties, the non-compliance, and why IBC is designed and how it is different from IBC's provisions, how it is not falling part of IBC. Uh, uh, and then it also goes on with the distinction between proceedings under Section 138 of an Act and those under Section 27 of CP Act, because 138 pertain to dishonor of check, where assumption of debt is inherent in the offense itself, whereas in contrast, Section 27 of CP Act deals with non-compliance with consumer protection orders. So it also makes distinction that how proceedings under Consumer Protection Act are also different from NACT provisions. Then para 37, if the appellant's argument is accepted, home buyers who have already suffered immense delays and financial hardship would be further deprived of relief. Legislative intent behind consumer protection laws is to safeguard the interest of consumers and ensure accountability from service providers. Permitting a stay on regulatory penalties under the guise of insolvency proceedings would undermine the very purpose of the Consumer Protection Act and embolden errant developers to escape liability through insolvency proceedings. Home buyers, many of whom invest their life savings. So again, observations relating to home buyers, and then staying penalties that serve as deterrence against such unfair practices would render consumer protection mechanisms ineffective and erode trust in the regulatory framework. So statutory penalties, the regulatory actions, they will definitely not form part of the moratorium. Makes reference to P. Mohan Raj Supreme Court case only, where this court held that moratorium under 14 of IBC extends to proceedings under 138 of an act. However, a distinction between debt recovery and punitive actions needs to be created. So this is not a financial dispute, but enforcement of consumer rights. Consumer Protection Court, Consumer 4 hours orders. So distinction has been made. So that is how the appeal filed by the appellant cannot invoke insolvency proceedings as a shield to evade statutory liabilities. So the appeal was dismissed by the Supreme Court with these observations that consumer protection execution orders cannot be stayed due to moratorium under section 95 and 96 of IBC. So this is the last case that we are dealt. Quite clear cut that statutory forums, courts orders, courts penalties imposed under a Consumer Protection Act, they will not be treated as debts. They are penalties. Penalties in the form of either compensation under the Consumer Protection Act, statutory uh, special statute also, and they are also penalties imposed because of not defaults but deficiency in services to the consumers. So this is not a creditor-debtor relationship, but a consumer and service provider or supplier. So penalties imposed under those by the fora. They are not even forum, they are commissions. So consumer commissions. So they cannot be halted merely because personal insolvency proceedings have been initiated. Any questions or any points to be discussed? This or anything else, because this is the last case that we are dealing with. So anyone wants to say anything first in relation to this case or points that are made? PG proceedings, we all know. I mean, being a lawyer for many banks also, I know how to avoid surfacey action also. PGs just file an application, sometimes also keep it under defects so that they also take advantage of the interim moratorium just by mere filing of a PG application. So, of course, there are ways how, because of these provisions of interim moratorium, that also mere filing of an application by itself makes it makes the interim moratorium operative. So, considering all that, I mean, good observation in the context. We don't know. I mean, it's very because failure to deliver possession, residential units, home buyers. We all should know that this is not a CIRP matter, but a PG matter. So, not as if the consumer, but PG matter also, there might have been a CIRP also. So, PG, because only in cases of CIRP are being entertained. Where the
Yeah,
PGs are.
I was just wondering which is the CRP matter in this case. Like this personal guarantor, whosoever is the personal guarantor over here, must be
Yes.
having his own, corporate debtor. He must be
Yeah,
a,
must
a
be.
personal guarantor to that corporate debtor.
Yes, must be. But then parallelly, perhaps the consumer dispute must have already ended and then penalties were imposed. And penalties in executions, the promoters, the directors, managing director or managing director of the concerned, they are also made parties. So that is why directions penalties were imposed on them, not on the corporate debtor by the NCDers. So very different case scenario, but perhaps obviously the company must have gone into insolvency. That is why the PG was entertained. So that is there. So any other questions or doubts, sir, by any of the participants? We have almost reached 5 o'clock. So
No, it was very detailed analysis. Will you be sharing, sir, these slides?
yes, I will be sharing the slides in a PDF.
Okay, thank you so much.
Yeah, Apoorv, very well said. And all the 8 cases which you deliberated upon were
Yes.
really, a great piece of knowledge for all of us and highly enlightenment.
Yeah, so very different, some of them
Yes.
preferential from the very first case. There are some very different recent observations. I mean, different types of matters which have come to the Supreme Court. So, I mean, and very different points, very
Yeah,
different.
quite a few of them real estate, most of them, I
Yeah,
would say.
many of them are
Like
relating to real estate in some
real
way or
estate.
the other, but different observations, even if it
Yeah.
is by be it entertainment of 226 by High Court in certain
Yes,
circumstances,
yes.
or even MSME arbitration, I mean,
Correct.
after the acceptance of resolution plan. These are all very
Yeah.
different issues which I have not seen before. So, very different new observations coming in these judgments. So,
Yes.
quite helpful for us to refresh ourselves. I mean, preparing for this particular session, even I was enriched a lot. So,
Yeah. Like MSME thing, Felicitation Council thing to be, set aside by Supreme Court. Now it is a good judgment. Like any MSME council trying to step in during the CRP
correct,
proceedings, you can always show this judgment, and that will help you. So
That is true.
that's true.
That is true. So there are very different issues, very
Yes.
new issues that I've seen. So that's why I try to incorporate those in this session.
Yeah, and a good compilation, very good compilation, and
Yes.
a
I'm
light of
also
knowledge.
thankful to my own team also in office
Yes,
who have
yes,
compiled this.
yes. Very, very well done. Thank you. Nice.
Anyways,
Thank you so much for the presentation. Thank you so much.
Anjali, are you there? Anyone wants to say anything
Yes,
else?
sir.
Yes. So we are quite done with the session, perhaps. I think nobody else wants to say anything, right? Everybody has.
Thank you very much, sir. Session was very interactive and very wonderful. Sir, have you prepared any presentation also?
Yes, madam, we are sharing a PPT.
Okay. Yes.
Yes. So, anyways, I will share it with the participants, definitely.
Okay.
Yes.
Thank you very
And
much, sir. Thank you.
thank you.
All
Thank you
right.
so much. Thank you so much. And madam, please share the attendance. Please send us the attendance certificates for claiming
Sure.
CPRs.
That they will definitely do. You are paying to them for that.
Yeah. Because very, very important for us also, and we are at the fag end of the year, so we have to do these
CPs.
limited,
Right.
these mandatory
Okay.
CPRs which we have to do. So, yeah, but in the process we learn a lot. So, and
We
thank you
learn a
very
lot. We learn.
much.
See, I tell you what, I mean, for
Yes,
preparing
yes,
for these sessions, or maybe I have co-authored a book on IBC. It's by Taxman.
okay,
So while doing that, I mean, we learned a lot. I mean, of
yes,
course, we all do it because I'm representing many creators and for FCs and as well as IBC. I've been there throughout since 2017. I've been to courts, but it's very. I mean, whenever you learn something new out of every session, I mean,
yes.
it's
True.
always. And Mishra ji, I'm very thankful. You have been very participative.
Thank you, thank
Sometimes
you so
in some
much.
sessions, all participants are always on mute mode. So you have kept it alive.
Thank you so much. Thank you so much.
All right. Thank you. Thanks to everybody. Thanks.
Thank you, sir. Thank you once again.
Thank you.